So welcome to Virtual Venture Cafe, everybody. We are here for Patent Strategy for Entrepreneurs, the application process and prosecution. Before we get started, just a couple ground rules from the top. Please keep yourselves on mute unless otherwise prompted by the presenter, and also use the chat function at the bottom to drop a question anytime, and we'll get to it in the order that we best can. So before we get started, I want to introduce our presenter. Stephen Ho is a patent prosecution advisor, and he got his degrees in physics from MIT and in engineering, graduating Pi Beta Kappa, and then after NYU Law School, he finally realized, sorry, what I'm trying to say is that he didn't have enough degrees, so he went and got one more of those. Now he's here with us. He's going to be doing a 10-week workshop at MIT in the fall. So Stephen, unless I've missed anything, please tell us a little bit more about what we're here to do today.
Sure, that sounds good. Dan usually starts off by just discussing our firm a little bit, and then I will jump into the presentation here.
Great. So I'll introduce Stephen and the topic by just saying that we're all inventors as well, like you guys. I started as an inventor back in college at MIT. Ended up getting something like 25 patents. Ultimately, my friends and colleagues started asking me for advice on the patent process. And after pulling their hair out, working with larger law firms, initially I started as a hobby, helping my friends and colleagues from NASA, MIT, Carnegie Mellon, etc. Eventually, I decided to turn it into a business. I would like to say one thing. As a founder, I remember when I was working at my company, one of the most gratifying things was getting this big fat envelope in the mail from the patent office. Usually we don't get mail from the patent office since it's all electronic. And I got my first issued patent. And that was one of the most gratifying experiences at my company. In addition to, of course, our first customer, it was one of the most gratifying experiences. So when we work with other inventors, we love to get that same excitement and gratification through the people we work with and relive that experience. You heard about Stephen's background. Stephen today will be talking about patent prosecution, filing patents, and the process of getting a patent at the patent office. And I'll turn it over to Stephen.
Okay, great. Thank you, Dan. So let me just get my presentation started and share my screen here. Can you guys see this? Can everyone see my presentation?
Yes, we can see it.
Okay, all right, perfect. Yeah, thank you, Sean and Dan, for the introduction. So without further ado, I'll just jump right in. So just to give you guys some context, we've been teaching patent webinars on various topics, both through Venture Cafe Cambridge, as well as some other hosts that have been hosting us. This is now our, I don't know, I guess our 7th or 8th this summer, ever since the COVID pandemic started. So everyone's indoors and we can do this online now. So today's topic will be on the patent application process and prosecution. And just as a heads up, I will be teaching this with the assumption that you don't know anything about patents. So those of you who have attended our webinars before or who have some experience patenting, some of this may be review. So I promise that this will be the last time that I read verbatim from the slides, but this is something that we sort of have to do. So this webinar is strictly educational and of a general nature and should not be considered legal advice for your particular situation. Attending the webinar does not constitute forming an attorney-client or agent-client relationship, and we are not liable for any consequence resulting from acting in reliance of the webinar or slides. So with that being said, let's get started. I'll just start off, brief introduction, what is and is not a patent. There's a lot of misconceptions there. And of course, we will discuss what are the parts of a patent and what are patent claims, and then finally get into the meat of it, which is patent prosecution. Okay. So what is a patent? Patent is a type of property right. It enables the holder to do one thing, which is to exclude other people from doing 4 things. And this is very important: making, using, selling, or importing the claimed invention, right? So it's a very powerful right. But there are some limitations to this, and there's 2 types: time and place. So a patent is limited. It's limited to a certain term of time, which we'll discuss. And it's only effective in the jurisdiction that granted the patent. There's no such thing as a worldwide patent. Some of you may have heard about the Patent Cooperation Treaty, or the PCT. I'll discuss that later at the end of this talk. But that's merely a process that makes it easier to be granted national protection. But when you do want to exercise patent rights in a particular country, for example, stopping a manufacturer in country X from making your invention, you have to get a patent in country X. And just like any other property, this can be sold, bequeathed, or licensed to other people. And indeed, that is the primary way in which patents generate money for their holders. So the first technical term that I'll introduce today is called infringement. So to use the property right analogy, this is when you trespass on a patent. That's when somebody does one of these four things: making, using, selling, or importing the claimed invention without the patent holder's permission. I do want to emphasize that patents are a so-called negative right. That means it's the right to stop other people from doing something, but just because you have a patent, in fact, it doesn't mean that you have an affirmative right to practice your own invention. So there are some possible reasons that you could be prohibited from making, using, or selling your own invention, even though you have a valid patent. One could be there may be other approvals necessary. For example, the FDA. If you invent a new drug, you may need to get FDA approval in addition to getting a patent in order to practice your invention, right? Next, perhaps your invention is otherwise illegal. If you invent a new type of nuclear weapon, for example, there could be some national security issues regarding that. And then third, there is an issue called blocking patents. So for example, suppose Sean is the first person to invent a chair and he gets a patent on a chair. Then a month later, Dan invents the first rocking chair and he gets a patent on the rocking chair. Well, in order for Dan, or anyone else for that matter, to make a rocking chair, they have to make a chair. So Dan would be infringing on Sean's chair patent. So for someone to practice a rocking chair, they would have to get licenses from both Sean and Dan. So why do we have patents? I'm only mentioning this because this will motivate how the patent prosecution process works. We can think of patents as a deal that's struck between the public and the inventor, with the public being represented by the government. So they will grant the inventor a limited monopoly with those limits that we talked about in return for the inventor disclosing the invention to the public, right? And the idea behind this is that this is supposed to spur innovation, and it promotes the growth of public technical knowledge by bringing information into the public domain faster by incentivizing inventors to do this. There's a question, of course, about whether this deal is fairly balanced, because we sort of have a one-size-fits-all approach to patent law. No matter how big or how small the invention is, regardless of how fast that technology is moving, we have the same laws in place. So it's probably not a perfectly struck deal, but it works very well, and there's a lot of evidence for that all over the world. So when does the patent expire, right? This is something that a lot of people ask about, and there is some confusion. So it used to be, when you talk to some older, probably now retired engineers and scientists, they'll tell you that it expires 17 years from the date of issue, right? That was the traditional expiration date of a US patent. But nowadays, and this is harmonized across the world, it generally expires 20 years from the earliest effective filing date, but you can only start practicing those patent rights when the patent issues, right? So if you shave off the amount of time that the patent is pending in the patent office, that will give you a efficacy period of a little bit less than 20 years. I say approximately 20 years for another reason as well. There is something called patent term extension or patent term adjustments, but that is a thing that comes up when you're prosecuting a patent. It accounts for either delays in the patent office or delays in the FDA in terms of approving your drug. You can actually get your patent term adjusted for those reasons. Okay, let's just quickly look at some parts of a patent. Some of you may have seen the cover of a patent before. Just like any other type of technical or legal document, it is extremely boring, right? Let's just face it, it's just the way it is. So how do you know it's a patent? Well, of course, it says right there in the upper left, United States patent. And it will list the last name of the first name inventor, Peter Kunert, in this case. And it shows his country of residency. So he is in Germany, DE. And it is assigned, presumably this is his employer, at least at the time of the application, Robert Bosch. There's the application number, 13/ and then a 6-digit number. So that's the serial number that was attached to the application when he applied. There is a PCT associated with this. You can see in the lower left, PCT filed. So that is a corresponding patent cooperation treaty application that was filed that's related to this US patent application. Then at the top, upper right, says US 8 million something, right? That is the patent number. So when we reference issued US patents, we use those numbers. And then the date of the patent, that is the date that the patent was issued. So that's the first date in which the owner of the patent can begin enforcing patent rights. Not before that, but only after that, of course. A few other things to note. This is just some trivia. In the United States, patents are only granted on Tuesdays. So every Tuesday, slightly around after midnight, the US Patent Office will grant or publish a whole bunch of patents that are issued from that day. All right. So generally, how do we refer to patents? Of course, if you can use the patent serial number, 8 million, something. But if you're referring to a bunch of patents and you are referring to the same patents over and over again, it's customary to look at the last 3 digits. In this case, we would call this the 348 patent. So this is a real patent. I will be using this as an exemplar when talking about patent prosecution. Or we can just refer to it by, of course, name the inventor, just like in any scientific publications, the Kuhner patent. The title of this patent is very simple. Pressure sensor, right? If you just go back, if you look at field 54, it says pressure sensor. I would say that this is a relatively simple title compared to most titles that practitioners like my firm and other people use. The important thing is that the titles have no legal significance. So no one really cares that much about what the title actually says. It's the claims that are the most important part of the patent. And then, unlike scientific publications, the order in which inventors are named also has no legal significance. So that's something that you can use to negotiate with your fellow co-inventors if it's important to some, but maybe not to others. Okay. So I will skip this for now. So in terms of trying to understand what the invention is, the 2 important parts are drawings and specifications. Drawing, pretty self-explanatory, right? Graphs, flowcharts, schematics, any other thing that is not expressed in words. And then a specification. This usually occupies the meat of the patent, right? It's paragraphs and paragraphs, could be dozens or even hundreds of pages. And it has to satisfy various parts of the patent requirements: written description, enablement, and best mode, right? So if you attended our previous webinars on those topics, you know what those requirements are, so I won't get into them today. But the most important part of the patent is, if you look at it physically, usually it's at the end, it's about the claim. So the protection of your invention is limited to what you actually claim. And the best analogy that people tend to come up with is you can think of it as a property deed defining land ownership, right? So if there is some kind of dispute between myself and my next door neighbor about where the boundary is, then we have to look at what the deed says regarding what that is. It may not necessarily correspond to something that's naturally there, like a river or a sidewalk or anything like that. We have to go back to the deed. There are 2 general principles by which patent laws around the world have done claiming. The United States traditionally had been much more central. This was back in the 19th century, but now the worldwide movement is towards peripheral claiming. So the best analogy I can use is in terms of property deeds. You can think of central claiming as signposts, right? To say, oh, my property is that big red house over there, and then you describe the house in great detail, and then you say, oh, and some of the land around it. So you're focusing on the important part of that property, right, which is the house, but then it's really difficult to know where the boundary is. Peripheral claiming is the complete opposite. It actually defines in great detail where the boundaries are, but not necessarily what is inside. So with patent claims, most of the arguments and disputes that people have are over what's at the boundary. So it's peripheral claiming that is now the parts of everyone's focus. So those of you who've actually read patents will be very familiar with this, which is that a claim is always a single sentence. And it's like, oh wow, I have to describe my invention in a single sentence. Yeah, in a sense, yes. So the claim itself is a single sentence. But you can use words and phrases that have a much longer definition elsewhere in the specification, right? So how do we understand how claims mean? Especially when you apply for a patent, How does the patent examiner understand the claim? And then just as importantly, when the patent is issued and other people are trying to understand what is the scope of your invention, how do we understand the scope of that? So this is one of the rules. So I will reference occasionally something called the MPEP. So in this case, I reference MPEP 2111. That stands for the Manual of Patent Examining Procedure. That's like the Bible of patent agents and patent attorneys. And it basically gets into very great detail. I think it's something like 3,200 pages in paper form, describing how patent examiners and practitioners should understand every aspect of the patent laws and regulations. So according to this rule, during patent examination, the pending claims must be given their what's called the BRI, broadest reasonable interpretation that's consistent with the specification in light of the specification as it would be interpreted by one of ordinary skill in the art, right? So it sounds like a pretty good rule to follow. And then here's something that really helps as well. It's called the you can be your own lexicographer rule, right? So this means that you can actually invent your own words in the patent application. It makes sense that we have such a rule, right? Because when someone is an innovator, they are typically inventing concepts or ideas or systems or even chemicals that did not exist before, right? And then they have to come up with words that describe those ideas. But here is a particular rule that you need to watch out for though, right? So when a term is used in the claims, that they may be given special meaning in the description of invention, but no term may be given a meaning repugnant to its usual meaning. So you cannot redefine, vector, for example, to mean something else. Obviously, vector itself has multiple meanings depending on whether they're talking about biology or physics or another technical field, but at least within that field, it has to be pretty clear what you mean by that term. Okay, so here's an example of claim 1 from that Kuhnert patent. You can see this really is just a single sentence, and this is a typical length for a claim that we deal with, especially in engineering, right? So you can tell that it describes parts of the pressure sensor and the relationship between those components in relatively great detail in a single sentence. So this is the meat of what we do, and of course, when we work closely with inventors to understand our invention, we need to describe your invention in this way so that there is a clear and hopefully unambiguous claim to your invention. Let's break this down a little bit. So the first part is just a phrase that describes generally what the invention is, right? So a pressure sensor for use as an airbag sensor of a vehicle. So that just frames what this is, right? We're not starting out by talking about some components and then you only find out at the end of the claim, right? In the very beginning of the claim, we basically say what this is. And it has a special comprising word, transition, comprising, and then there's a whole body of other text that tells you what is in that pressure sensor, right? And each of those components are what we call claim limitations. So the more limitations you add, it narrows the scope of the claim, right? Because then there's fewer and fewer pressure sensors out there that would satisfy these limitations. If I just highlight the first few words of each limitation, this makes it a little bit easier to read. Unfortunately, in patents, they don't highlight it for you this way. All the text is treated the same, so you just have to kind of annotate it yourself. Now let's talk about those transition phrases. These are the most common ones, comprising and consisting of. So what do people think these mean in the patent law? I'm going to take a short break here. I know I've been talking quickly. Whoops. Let's use the chat. Please put your ideas in the chat. What do you guys think these words mean, or the difference between these words? I'll put it that way. What do you think the difference is between comprising and consisting of? Okay, I will tell you. So the word comprising is considered open-ended, whereas consisting of is closed-ended. And I'll give you an example of what that means. So when I have a claim that says a widget comprising X and Y, that covers a widget that has limitations X, Y, and possibly something else, Z, which is not mentioned, right? But consisting of is close-ended. That means when I say a widget consisting of X and Y, this claim would not cover a widget that has X, Y, and Z, because that means the claim means a widget consisting of X and Y. That means it must have X and Y, and it must not have anything else, right? So that is the way that these words are interpreted in the patent law. I'm just going to look at what people are texting. Give me 1 second. Dan, do you have anything to add at this point?
No, I don't.
Okay, so I know that people have some very interesting comments that, let's see, okay, all right, cool, sounds good. All right, let's continue. There is a third one that people, this usually comes up in chemistry and material science, called consisting essentially of, and this is what we say is a partially closed transition phrase. That means it's basically consisting of, but then it allows for a small number of exceptions, like the exception of additional elements that do not change the essential function or properties of the composition. So if I have a, for example, it has a semiconductor device, and I say there's a layer consisting essentially of silicon, right? That means it's basically silicon, but I'm allowing for some impurities that are not affecting the properties that are relevant to the operation of the device. If you want details about this, I have in the lower left, MPEP 2.111.03 that you can look up, where they have a lot more examples if you think that this is something that would be important to you. In chemistry and pharmaceutical arts, they do sometimes actually put in chemical formulas directly to the claim. So you can see that here, right? And they have some, they talk about different groups. For example, they have X1 and X2, and then it gives you some limitations as to how those work, right? So in this case, it says compound of formula 1, and it gives you the chemical formula. And we have an X1, X2 group, and then it says X1, X2 independently, a halogen atom selected from the group consisting of fluorine, chlorine, and so on, right? And in this case, they actually did want to use consisting of, they intentionally narrowed it down because it only wanted to select from those groups. So how are claims organized? As you may have seen, in the vast majority of patents, there are multiple claims, right? It's rare that a patent only has a single claim. So in this case, we already saw claim 1. Claim 1 has that really long paragraph that we saw. And then the other claims refer back to an earlier claim. So claim 2 will say, the pressure sensor claims to claim 1 wherein, and we add some additional words. So let's talk about how those work. Those are what we call dependent claims, right? So there are 2 independent claims, one and something else. So those claims don't depend from anything. In patent law, we use the term depend from, not depend on. It took me a few months to develop that habit, but that's just the term that we use. And then the other claims depend from either an independent claim or a previous dependent claim. So we call those dependents. So how do those work? Let's talk about it. Claim 2 is actually extremely short. This is the entirety of claim 2. The pressure sensor, according to claim 1, wherein the wall surface tapers in the direction of the small opening. So just from context, you can probably tell that somewhere in claim 1, we talked about a wall surface and we talked about a small opening. So claim 2 now talks about the relationship between those 2 elements. So my question to you guys is claim 2 broader or narrower than claim 1? What do people think? Use the chat box. See what people say. Okay, good. Yes, it is narrower, and that makes sense, right? Because now we're introducing an additional element or limitation that has to be satisfied in order to infringe on this claim. And then why do we have claims of varying scopes? Because claim 1 already covers a pretty broad range of things. Claim 2 is a proper subset of that. Like claim 2 is not covering additional pressure sensors that claim 1 doesn't have. So why do we do this? So I will talk about that. Let's do I guess you can call it a Venn diagram, right? You can think of claim 1 as covering some subset of the universe of pressure sensors, right? And claim 2, like we said, is a proper subset of that. So there are some devices that are covered by claim 1, but not by claim 2, but then not the other way around. And then, you know, you can go further like this, claim 3, claim 4. So claim 3 and 4, one is not the subset of the other, but then they may have additional elements depending from claim 2, but then they're not mutually exclusive. So then 3 and 4 may have some overlap as well, right? So the reason why we do this is, I think just right here, this is a really good claim rule of thumb, right? And this sounds like a, I guess something that you might read from like a fortune cookie or something, right? Strongest claims are the weakest claims are the strongest. So I'll explain what this means. A strong claim has few limitations. That means it covers a lot of things, right? In that sense, it's a powerful claim to an invention that makes it difficult for other people to design around because it covers a pretty broad range of devices that you're trying to market. But it will face a high risk of being rejected during prosecution or rendered invalid in litigation. Because if you are a relatively broad claim, you are also covering a lot of potential prior art, right? So there's also much higher risk of someone who had already invented that before, right? So if I said something like a pressure sensor for use as an airbag sensor in a car, and that's all I said, then anyone who's invented an airbag sensor for use in the airbag of a car would be considered prior art against me, right? But if I talk about some novel features that I have that no one else has, then those previous ones would not be considered prior art against me. Conversely, if I have a lot of limitations, then this could be a legally weak claim in the sense that it covers only very specific embodiments, so that is legally useful. But at the same time, challenges against its validity in both prosecution and litigation are much less likely to succeed, right? So that's the trade-off you have here. And this is the reason why when we submit patent applications, we tend to have claims of varying scopes, right? To basically cover all our bases when it comes to the different types of claims that are possible. So let's see how this plays out. Suppose I am a startup and I have some very key technology that I absolutely want to protect with my patents, right? So I have my key technologies protected by, I can think of this as use like war analogies, right? There's like 3 levels of walls here protecting my key technology. And then I have some secondary technology that generates some revenue for me. It's kind of interesting, but it's not that important to my business. So it looks like it's somewhere in claim 2, but not covered by claim 3. So how does this work? Let's do this backwards in time. Litigation. So this is what happens after you already get your patent issued by the patent office. And then suppose you have a competitor who says, hey, your patent should be invalidated. And then they sue you in federal court, right? And it goes to the court, and then they're looking at whether or not your patent is valid. And this is something I need to warn you guys about, is that just because you get your patent issued by the patent office, there are a lot of venues by which your patent can be invalidated. A few weeks ago, we taught a seminar on post-grant proceedings, licensing and litigation, both here at Venture Cafe Cambridge and other venues. So if you attended those, you're well aware about the dangers of that. Okay, so this is how this would work. Your competitor would go to court and say, hey, we found newly discovered prior art. Sounds like a contradiction, but what this means is that prior art means that this was something that existed before your priority date. So perhaps someone invented this before and they already released it to the public. So those of you who attended our patentability requirements webinars would know what qualifies as prior art. Newly discovered means that the patent examiner and you as well as the inventor was not aware of this, right? No one's perfect. The examiner tries to do his or her homework in getting your patent invalidated, but they're not perfect, right? But guess who is much more motivated than the patent examiner? Obviously your competitors, right? They have a lot more resources and time, and they're if it's important enough, they will spend a lot of time and money to get your patent invalidated. So they'll go to the court and say, hey, we're going to sue you because we found newly discovered prior art to get this invalidated. And if it turns out that, oh, lo and behold, it is, then boom, too bad. You lost claim 1 and claim 2, right? But at least you had claim 3. That was not encapsulated by the newly discovered prior art. So at least your patent can still protect your key technology. You did lose some claim scope, so you lost protection over your secondary technology, but at least you kept your key technology because you had varying claim scopes, right? So that's in litigation. Let's talk about prosecution. This is earlier. This is what happens in the patent office. So let's take a look at this case. So this time it's the patent examiner, right? You're applying for a patent. You say claim 1, claim 2, claim 3. And then the patent examiner says, hey, I am going to reject your claim 1 and claim 2 because I found this prior art that is covered by them. So what happens? The good news is during prosecution, you have an opportunity to amend your claims, right? So one thing that you could do, as long as you don't add new matter, so that's one rule. You cannot come up with new features to add to your claims that did not already exist in your original application. But what you can do is you can amend the claims in accordance with the spec. So you can cancel claim 1, and then you can amend claim 2. Obviously, this is just pictorially what this looks like, to overcome the newly discovered prior art, right? So you're avoiding the prior art, but at least this time, you maintained a pretty wide claim scope, and you can keep your secondary technology protected, right? So this is the power of doing claim amendments during prosecution, which is not possible once the patent is issued. Well, actually, technically, there are some ways to do that, but we won't talk about them here. But at least when it comes to litigation, you don't have an opportunity to do that. So this is where it gets a little bit tricky, right? Especially if the claim boundary is sort of in question, because when you're trying to describe something technical in English words, it's not as precise, of course, as other ways that scientists and engineers are accustomed, like using mathematics or chemical formulas or other things, right? So what happens if the claim boundary is in question, right? How would they argue about this, right? So I'll give you a second to think about this. Where would they argue the boundary is? So what I mean by those figures is that orange, yellow thing, that is the product that the accused infringer is making, right? So they're making something that looks like it's kind of inside my claim scope. And at the same time, they found some prior art that seems to be slightly outside of my claim scope, right? So for me as the patent holder, I would argue that my claim boundary is exactly between those two, right? So it's inside the prior art, it's just inside the prior art, which means that it's a valid claim, but the accused infringer is doing something inside my claim. So I get the best of both worlds, right? The accused infringer, they can go in two directions. They could say that the claim scope is actually wide, meaning, yes, I am indeed practicing what this claim is covering, but at the same time, it also covers the prior art, so the claim is invalid. So I'm not liable for infringement. They can go in the opposite direction too. They can actually claim a much narrower scope to say, guess what? Your claim is valid because it does not cover the prior art, but it doesn't cover what I'm doing either, right? So they have two different strategies that they could pursue. All right, so now let's get into the more interesting part of this talk, which is patent prosecution, right? This is why you guys signed up for this, I assume. So let's see how this works. What is prosecution, first of all? It is the process by which the applicant, usually represented by an agent or attorney, seeks to obtain a patent from the US Patent and Trademark Office by communicating with a patent examiner, right? So you apply for a patent, you go back and forth with the patent examiner, and then hopefully, eventually you get your patent issued, right? And at least for now, patent examiners are human beings. Who knows, maybe AI will eventually change that, but we'll see how that goes, right? Now there are, literally hundreds of rules of prosecution, but I just want to obviously tell you some of the more important ones. I try to base the presentation in general, actually all of our webinars, on the most frequently asked questions that our clients ask us, right? Because we find that there's a pattern of fundamental information that people want to know. So we kind of organized it this way. So the first is that a claimed invention is presumed to follow all the patentability requirements. So for those of you who attended our previous webinars, know that an invention has to be novel, non-obvious, right? And that your application has to enable someone having ordinary skill in the art to make and practice the invention without undue experimentation, right? There's a lot of requirements there. So you actually don't have to show that. So when you apply for a patent, you don't have to prove that it's new or it's not obvious or anything like that. It's presumed to be that way. The examiner has the initial burden of showing otherwise, right? And of course, if the examiner tries to show that, now you have to prove that the examiner is wrong. Here's something else too. Applications are confidential until 18 months after filing, and at which point they are published, and then the prosecution history both before and after publication becomes publicly available. So this is where I want to be a little bit precise. So you submit a patent application, and then 18 months later, it's published. We call that the patent application publication, PAP. And then sometime after that, or maybe even before, if you're lucky, your patent will be issued, right? So that's called the patent document or the patent number, blah, blah, blah. But then the publication of the application, those are called patent application publication number, and then there is some long number starting with the year in which it was published. So I want to make that very clear as well. So this will give you a little bit of pressure when you're applying for your patent. So, you know, if you're trying to weigh the pros and cons of this, you can say, when I apply for my patent, no one knows that I have this invention. But once it's pending in the patent office for 18 months, now the entire world is going to know about my application, right? So if I eventually do not get a patent, then the world just knows everything, right? Okay, let's see. Just want to look at the chat for a second. Okay, someone asked, Andy asked, does the prosecution history include a provisional abandonment? I believe the answer is if you had claimed priority to a provisional, if you claim priority to a provisional and then the non-provisional is subsequently published, then yes, the provisional would become available as well. But if the provisional is abandoned in the sense that no one had ever claimed priority to the provisional, then the provisional would be kept secret forever. Dan, is that correct?
Yeah, that's 100% correct. It wasn't clear what interpretation the question was asked.
Yeah.
But that's true about whether the provisional is published or not. If you were asking about whether the provisional is ever examined, then no, the provisional is never examined by the patent office unless there's a dispute on the priority date. For example, there's a prior art that occurs after the provisional but before the non-provisional.
Exactly. Yeah, that's right. And then the last rule that I'll mention is there's no piecemeal prosecution, at least the patent office tries to avoid it. So for example, like I said, there's a whole bunch of requirements that have to be met for you to get your invention. So suppose the examiner looks at your application and then already knows, oh, this is not novel because someone else already invented this before. They could, you know, just stop there, right, and say, oh, you failed at least one requirement, so you don't get it. But according to the no piecemeal prosecution, they have to examine all the requirements as well. So if there is something non-enabling, they have to mention that as well, right? If there is a spelling mistake in your claim so that it becomes a word that doesn't make sense, they need to point that out too. This is really just to advance prosecution, right? Just to make it faster, because if the examiner says, oh, it's not novel, and then they send it to you, then a few months later, you reply, you amend your claim so that now it is, then they come back and they say, oh, by the way, claim 17, you have a spelling mistake, right? And therefore, you know, they just waste time, right? So they want to make sure that you bring up all the issues as soon as they come up so that the applicant has an opportunity to respond to those. Dan, you have anything to add about the no piecemeal prosecution rule?
I can add an anecdote that
Sure.
that sometimes people are afraid that the examiner will go back and reject their application again, especially if they've had multiple rejections and they don't quite understand why. They think, oh, the examiner can go back and reject their application over and over again, but that's not really quite true. The examiner can only reject your application over new prior art if you've overcome the prior rejection. The examiner can go back and re-reject your application over the same prior art.
Right. Thank you. Okay. So what is the examiner looking for? And like I said, the examiner is just trying to show that the patent application fails to meet one or more patentability requirements, right? And if you have questions about
You're not listening.
Oh, okay. Just as a reminder, please keep your microphone on mute if you're not asking a question. Okay, cool. Yeah, so the examiner is trying to show that your patent application fails one or more requirements, right? And it's up to the burden is on the examiner to demonstrate this. Okay, and I know some of you had asked about provisionals, and we had alluded to it as well. So I just wanted to make sure that we clear up some misunderstandings about these, because we find that there is a lot of misunderstandings about the term provisional for patent applications. So in US patent law, the word provisional comes up in two completely unrelated contexts And this is what, if I had the power to change patent law, well, there's other things I might change as well, but one very simple thing would just be this, right? It's unfortunate that we use the word provisional in two different ways. One is provisional patent applications, and that's the focus of that we'll use here. And there's something else called provisional patent rights, right? So in the United States, there's no such thing as a provisional patent. So it's not as if the patent office will issue you some temporary patent pending some other thing, and then it somehow becomes a permanent patent. It doesn't work that way. So I will explain how it actually works. So for the past 25 years or so, patent applicants may submit an inexpensive, depending on your entity size, between $70 and $280, provisional patent application. So that's normally what people mean when they say a provisional. They mean a provisional patent application, and it secures your priority date. So as you know, with the way prior art works, if I submit a patent application tomorrow, then if someone else tries to submit a patent on the same invention after me, then I would get priority, right? We have a first to file system now in the United States since the AIA, American Invents Act, was passed in 2011, coming into effect in stages, culminating in 2013. But there is something called a first to disclose shield, and that will come up as well when we talk about the timeline for applying. So for provisionals, the disclosure requirements are very loose, right? I've seen some disclosures that were pretty much just like photographs and an advertisement of the product, and that's usually probably not a very good one. And I've seen some others that were pretty much full patent applications, and then everywhere in between, right? And then there's a trade-off here. The lower the quality of the provisional, usually people do this because they don't have that much time or money to spend on it, and they're just rushing to get something in because their field is evolving very quickly, or they just want to get something on files because they have like an investor meeting coming up, right? So the lower the quality of the provisional, the more likely that a later challenge to a claim in the issued patent that relies on that provisional is to succeed in knocking it down, right? That makes sense. One of the rules about provisionals is that the applicant has 1 year to submit a non-provisional, so quote unquote normal or regular patent application that claims priority to their provisional. Some people in our field use the term convert, right? Convert a provisional to a non-provisional. And we had the discussion in our firm recently. Just to make it clear, there is actually a procedure in the patent office called converting a provisional to a non-provisional. That's usually not what you want to do. But that one is, that is literally saying, oh, I want to retroactively change my provisional to a non-provisional. And that's usually not what you want to do. What you really want to do is this. But colloquially, when people say converting a provisional to a non-provisional, this is what they really mean. They're submitting a new non-provisional patent application that then claims priority to the provisional. I know there are some practitioners out there who dance around it by making up their own terms. I know one who uses the word perfect. So they'll tell their client, it's time to perfect our provisional patent application, and we have X number of months to do that, right? Another rule is that provisional patent applications are never examined nor published, right? They don't even come to light until a filed non-provisional is either published or granted, where that non-provisional claims priority, right? And that makes sense. So you don't have the risk of filing something as a provisional, and then 2 months later, you change your mind, but, oh, I don't want to file a non-provisional. Don't worry, no one's ever gonna know about it. What about this other one, provisional patent rights? How do these work? This is something completely different, right? So generally speaking, patent owners may collect damages only for infringement after the patent issues. But this is something that allows you to, provisional patent rights is something that gives you retroactive damages, right? And this is how this works. Here's the timeline. You can do this for activities occurring after the publication of the patent application. You see why these words are very important, right? After publication of a patent application and before the issuance of the patent. So that could be any amount of time, right? Could be 1 day, could be years, depending on how long it takes for your patent to pending in the patent office. But it has certain requirements that are not true for patents once they're issued. One, it requires that the third party had actual notice. So you have to prove that they actually knew. That usually comes about when you mail your competitor your patent application publication, say, hey, by the way, this published yesterday, and we know that you're doing something similar, so I'm officially putting you on notice, right? And two, of course, just as a matter of fairness, the invention as claimed in both the published patent application and the issued patent is substantially identical, right? So just as a note, post-issuance infringement has no notice requirement. So ignorance of a patent is not an excuse. You can still be liable for patent infringement and liable for damages. So there's many different ways that you could have a timeline for patent prosecution. I'm just having this is just a very simple one, so please don't expect that this is what happens to most people. So first, an applicant might publicly disclose their invention, right? This could be at a conference or at a trade show, or maybe just on their website, or they try to have some pre-sales just to kind of test the market with how popular their product might be. And in the United States, that gives you a 12-month deadline to file at least a provisional patent application, right? Disclosing the invention. So once you have that in the door, that secures the priority date. And because we have what's called a first to disclose shield up to 12 months, you are okay. Then after that, you have another 12-month deadline to file a non-provisional or a normal patent application that claims priority to that provisional, right? Then the patent office may issue an office action to say, oh, by the way, you know, some of these claims are not novel or some other defect in your patent application. And then 18 months after you file, non-provisional application is published. And again, this is only an exemplary timeline. It's possible that this office action occurs after 18 months, right? But then once the non-provisional application is published, not only is the application published, which means that the whole world now knows that it exists, but its prosecution history also becomes available. So this office action that I have here, at the time that the office action was issued, no one knew about it because the patent application was still secret. But then once that non-provisional application is published, the office action also becomes published as well, right? So the applicant would respond to the office action. In many ways we can do that we'll see in the case study. And then congratulations, you get your notice of allowance, and then the patent will issue, right? And just as a note, just to remind everybody, the expiration date of the patent is generally, you know, pending those other issues with patent term adjustment and extension, 20 years from the filing date of the non-provisional application. So this is also another advantage of filing a provisional, right? Is that it gives you some, it changes the timeline for the expiration of your patent. Okay, so let's just look at a little case study here. This is the same patent that I mentioned before with the pressure sensor in the airbag. And just as a note, this was literally just a random patent that I found just by looking up different ones to see if I could find a good case study. So if you look at the note at the bottom, none of us are involved at all. I don't even know, we don't know the law firm involved, nor the inventors or the examiners. So we just have no connection to anyone, right? So we're not, well, one, there's no risk of inadvertently disclosing client confidential confidence. And of course, we're not criticizing anyone in particular as well. This is solely from the public record. So many of you will ask, how do I look up the patent prosecution history? So I told you that once a patent application is published, you are able to follow its prosecution history. So this is how you do it. If you actually Google up USPTO PAIR, or PAIR stands for Patent Application Information Retrieval, you will get this website, and then you can enter, you can search for an application or a patent by various things, the application number, the patent number, and so on. And if it's already been available to the public in terms of being published, you can find the entire prosecution history. So that's literally what I did when I was putting this together. Okay, so let's take a look at this timeline. It was filed back in 2011. And then you can see if they went back and forth. OA stands for office action. That is when the patent office issues a communication to the applicant. Non-final office action, then the applicant replies, then the examiner came back, and then they go back and forth. They even have an interview, which I'll talk about, and then it finally results in an issued patent. Okay, so this is the original claim. They filed it as claim 11. It later became claim 1, but notice that it's much shorter than the claim that we saw in the beginning of this talk. And this is very typical. Usually when people submit their first patent application, the claims are relatively short, right? Because they're trying to get broader claims. And then during prosecution, the claims tend to be narrowed, which usually entails adding additional words. And so this is very typical. Okay, so let's see what the examiner said. Again, the rejection itself was many pages long, but I just wanted to point out one section just to give you a sense for how this is done. The examiner said, claim 11 is rejected. This was before American Invents Act. So they're just trying to be technical about which part of the law they're referring to, as being anticipated by Wagner. So that's the technical term when we say that there is some prior art out there that makes your invention not novel. So there is this Wagner reference that anticipates your invention. And then the examiner does an element by element analysis. They'll actually look at the Wagner reference, look at your claim, and say, look, the Wagner device covers each element of your claim. So therefore, I'm rejecting your claim, right? So, and they, of course, they point out the corresponding features, right? Technology here is not important, so I'm not going to dwell on that here. So what did the applicant's attorney say? They went back, and the parts that were underlined were added. So these are amendments to the claim. So they amended the claim to say, oh, it has a small opening and a large opening. So what the attorney is doing is they're amending the claims to narrow it, right? They're adding additional limitations to the claims. In this case, a small opening, a large opening that Wagner does not have. And then the attorney explains why Wagner doesn't have it, and then requests that this rejection be withdrawn, right? So the examiner, this time it's the supervisor, comes back and they actually say, applicant's arguments have been fully considered, but they're not persuasive, right? It's like, oh, thank you for writing this, but too bad for you. And then they go on and then they actually try to interpret the words small opening and large opening. And they show this thing. Again, this is, the technology is not important, but what they're trying to do is the examiner had highlighted the black part and said, hey, we have this long, narrow tube, but then there's this cavity that's flat beyond that, and I'm considering that to be the large and small opening. And then the applicant's like, well, that's not really what I mean. So then now they go back and then they rewrite their terms, their claims a little bit. And the examiner actually throws them a little bone and says, but you have this claim 13 that would be allowable if rewritten in independent form, right? And what's nice about that is if you look at 12's claims 12 and 13, they mention these two other elements, tapers in the direction and a straight design. So this time the examiner says, you know, something like this I would allow, right? And again, we don't know what the applicant really wants in terms of what embodiments that are mentioned are most important for them to protect, but apparently that seems to be pretty good. So they held what's called an examiner interview. And at my firm, we highly recommend doing this because usually office actions and replies to office actions, they're in writing, right? And it takes a long time, it's in the public record. Both sides may feel a little bit restricted in what they can say. But just like anything else in life, when you do this over the phone and nowadays video conference, like WebEx, according to the USPTO, people can be a little bit more free to discuss things. And it's not recorded, the exact content of that telephone call or video call. The transcript of that is not available, right? Unlike a written response and written office action. Instead, both sides will submit a summary. And in this case, the examiner really just said one sentence. He said, the examiner agreed that the applicant's newly proposed amendment, blah, 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 overcame the Wagner reference. And this obviously made prosecution occur much faster. So all the parts that I underlined here were added to the claim. So notice that, as I mentioned, when a claim goes through patent prosecution, it tends to become much longer, right? Because we're adding limitations that satisfy the patent examiner. Okay, so another question that we get asked is, how much does this cost, right? Everyone knows these things can really add up. First, I just want to mention that when you apply, there's 3 different sizes of entities that we have to consider. Let's start with small. Small is anything that is a nonprofit or has 500 or fewer employees, right? That's many of you who are starting a startup and qualify for that. Micro is even smaller than small. Micro is something relatively new, and you can read for yourself how you can qualify for that. In case you're wondering, that annual income requirement, if you file jointly with your spouse, that includes your spouse as well. And then regular are anyone who doesn't qualify, right, for small or micro. And these will give you 3 different fee rates for these things. So regulars, of course, full price. Small is generally 50%, a 50% discount. Micro is a 75% discount. So these are the fees. You can look these up. They're obviously available on the website for the USPTO. But just by doing the filing, searching, and examination, if you're a small entity, it will cost $785, right? Micro entity, $355, right? So, and again, these are just the USPTO fees. If you hire an agent or attorney to prepare these for you, they have their private fees as well. But you're not done yet. It turns out that you have to pay money to have your patent issued even after you get your notice of allowance. You have to pay what's called an issue fee. And then every few years, you have to pay what's called a maintenance fee as well, due at 3.5, 7.5, and 11.5 years in order to keep your patent active. And if you fail to pay those maintenance fees, then your patent will expire early. So you have to think about whether those are worth it or not. Okay. I just want to mention some brief things. I know we're running out of time. There is something called continuing applications. And this is something that these are new patent applications that you file that claim priority to an earlier filed parent. And there's 3 types depending on the scope of the specification and claims. I'll let you read that for yourself. But these are ways in which you can capture greater claim scope that was not apparent in your original application. And this is very helpful when you are a small company or even a large one that is developing a whole patent portfolio, right? Investors really like to see these because these are efficient ways for you to get much broader patent claim protection than you would have otherwise. Right? Again, I focused on US filing, but if you're interested in international filing, every country has their own rules and you have to apply for different countries, generally speaking, but then there are ways to simplify that. One of the first international IP treaties was the Paris Convention. The vast majority of countries are a member of this, and these are its 2 most important principles. One is non-discrimination. So you can't discriminate you cannot discriminate against people of different nationalities, right? So if a scientist in Japan wants to apply for a US patent, the US Patent Office has to treat them the same as they would a US citizen applying for a patent. Priority right, that's also very important. So an applicant may use the first filing date in a contracting state as the effective filing date in another, right? So if I apply in the United States for my patent, and then 3 months later, I file in Canada, then the Canadian Patent Office would use my US patent filing date in terms of judging novelty. And of course, there's the Patent Cooperation Treaty. This is the PCT. This makes it much more streamlined. You file a single PCT application to what's called a receiving office, and then you can decide many months later, 30 to 31 months, depending on the country, whether you want to enter the national regional phases at those times. I will end that part there, but I do want to mention one thing, which is called patent prosecution ethics. This is something that you have to watch out for when you're applying, right? So one of the ethical obligations when you are a patent applicant is you have to reveal to the patent office any information you have that may be detrimental to the novelty of your invention, right? So if you know of someone else that invented something very similar to yours, you actually have a duty of disclosure. What if you fail to do that though? Someone else can actually use that against you and get your patent invalidated by accusing you of what's called inequitable conduct. And that could actually render all of your patent claims unenforceable. It's a pretty high bar to meet. There are 2 elements. They have to demonstrate an intent to deceive the USPTO, right? And that the information withheld was material to the patentability of one or more claims. But it's just something that you need to understand. So who is bound by these obligations? Every named inventor, every agent attorney who prepares or prosecutes the application, and anyone else substantively involved in that process. So it's a pretty wide net, and you have to be very aware of this. Otherwise, you can get your patent invalidated. This is not that important, but this is just a case where someone was found liable for inequitable conduct. This is a case, just to full disclosure, I used to work at Finnegan. Not at that time though, I was there before this case came up. But basically this talks about what happens when you have the same agent or attorney represents two different clients working on similar inventions. So those of you who are considering hiring a patent agent or attorney to represent you, but you know that they work with one of your competitors, what are the ethics with that? I encourage you to look at this case. But the bottom line is there's no conflict of interest if the claims do not overlap, right? Even if they may be economic competitors, that's different from a legal competitor in the sense of what the patent office is interested in. Although there are many other firms, for example, ours, we also try to avoid economic competitors as well, right? Okay. So here's some tips about prosecution. This may sound a little bit counterintuitive, but you actually want your patent application to be rejected the first time. And this sounds very different from other things you apply to. You know, no one says, I'm applying to my dream college and I want to get rejected. And what? That's kind of strange, right? So why is this? So we want to think of patent prosecution as a negotiation process, right? We try to start with broader claims and then they get rejected. And then we understand how far can we go before we finally get something that is issued. As an example, suppose suppose someone decides to sell a house, right? They put it on the market, but they don't say a price. And I like it, so I immediately make a bid. I say, oh, I'll buy it for $500,000. And then the buyer immediately accepts. Is that good or bad? Obviously that's bad, right? Because I probably could have gotten a much better deal. And that's the same thing with patent applications. If you apply for a patent and it instantly gets granted, then you probably think, oh man, I probably could have gotten broader claims. And I lost the chance to do that. So this is all pretty self-explanatory, right? Just be careful when you're doing with the kinds of arguments that you're making. In the slide, I referenced something called prosecution history estoppel. So what is that? That means that once you make a claim about, for example, what your invention is or is not, that goes into the public record and that could be used against you later on. So you have to be very careful about those kinds of things. So I just want to thank, of course, my own firm, American Patent Agency, for supporting this, and to Venture Cafe Cambridge for hosting us. You've been with us for most of this year, every time we did it, either in person or online. And of course, I want to credit my co-instructors from previous seminars for helping with these slides. And I just want to make a note. Next August, next month, we are teaching a similar webinar. This time it's on claims, inventorship, ownership, and patent rights. So if those of you if you have disputes about who counts as a co-inventor on your patent and who counts as a co-owner, you may want to attend that. And just like with this event, just go to Venture Cafe's event page to sign up. But even more excitingly, we are launching a webinar series at MIT in the fall. This will be from September to December. The tentative date would be every Monday night for 1 hour at 7:30 p.m. Eastern Time. It will be basically an expanded version of the talks that we've done so far, but in a much more coherent way, because we'll assume that people have attended previous ones, so we can get into much more exciting things. So with that, I'll end it here and open the floor to question and answer. Thank you.
I don't know if there are any questions, but I did think there was something very interesting that Steven said, that maybe somebody could take a stab at answering my follow-up question. So Steven said that every patent that's filed with the patent office is presumed to be patentable. So it's presumed to be novel, non-obvious, and so on. Does anybody want to answer my follow-up question I asked in the chat? Is that logical or illogical? Why should it be that if you file a patent application, it's automatically presumed to be patentable? Does anybody want to answer whether they think that's logical or not? And it really doesn't require any expertise or anything, knowledge about anything in the patent system. Anybody want to take a stab at that question? What they think? It really has nothing to do with the law. It's really a question of why does the law set up that way? Does anybody have any insight or ideas? Well, I guess I could give my insight. So in my mind, this is analogous to you're innocent until proven guilty. Because imagine you were accused of a crime, and it was your job to prove that you were innocent. Where would you even begin? So in my mind, my interpretation is the reason for this rule is if you were to file for a patent application and you had to establish that your invention was novel, without the examiner issuing first telling you why it's not novel, where would you even begin? You'd have to analyze all the prior art, which is unlimited, and it would basically be, for all practical purposes, impossible for you to establish like proving a negative. I saw some comments. What is the best book to read to be able to write claims and patents as close as possible to what a patent lawyer does? That's a great question. Well, recently I ordered this book off of Amazon. Let me fix this background. Now, Stephen will probably tell you that this book is a bit too advanced, so Stephen can recommend the other books. But I recently ordered this book from Amazon. This book is what people use in law school. So if you really want to write, read about the case laws and litigation issues and claim drafting, you can read this book by Mergis and Duffy. And it looks like Stephen has some recommendations for some more elementary books.
Yeah, I would start with the Durham book, Patent Law Essentials. That's actually targeted towards scientists, engineers, and entrepreneurs who just want to understand patent law. And to be honest, we sort of ripped off the name of our workshop from the title of that book. And if you're even more interested, there is a slightly deeper book just simply called Patent Law by Janice Mueller. And then the one that Dan recommended, that gets into the weeds of everything even more, the famous Mergis and Duffy case book. But for your purposes, I would start with the Durham book.
Can you claim a patent pending with a provisional? Yes, provisional counts as patent pending.
And just to make it clear, yes, as soon as you file a provisional or non-provisional, you can claim patent pending, but not before that. So when you're preparing a patent application but not yet filed, you cannot say patent pending, legally speaking.
Okay, the other book I mentioned is Patent Law and Policy by Mergis and Duffy. The reason, I'm gonna go on a slight aside if there's no other questions for a minute, but this book is very fascinating because it also goes into the philosophical foundations of patent laws. For example, it goes into the ancient debate between Aristotle and Hippodamus of Miletus about whether patents are socially beneficial or not. So the philosophical foundations of patents are also quite fascinating. We got another question. In your experience, are there regions in the US that are known for having more aggressive or more experienced patent lawyers or firms? Coming from Vancouver, Canada, for example, there are some patent lawyers in for technologies in the forestry industry, but not many lawyers experienced in advanced robotics. Do you want to answer that question, Stephen?
I mean, I think just like any other industry, yeah, people will naturally gravitate towards where their industries are strongest, right? Like if you're doing a lot of biotech industry, then San Francisco Bay Area and Boston are pretty big. I think that's just naturally how it is. But you have to keep in mind that patent law, unlike many other areas of law, are solely at the federal level in the United States. Same thing in Canada. Same thing in Canada as well. And it just tells you about how uniform most countries want to make it. So nowadays you have patent agents, patent attorneys that operate all over the country with clients all over the country and the world as well. So I think the geographical limitations are much less than they were before, and also compared to other areas of law. Who would be the best for med tech and medical devices? Since this is an educational seminar, we can't really we can't really say that here. So you can just contact us off on the side, and we can talk about that offline.
How many people in this room have filed for at least one patent? Sometimes we do a poll question, but since we're not hosts, I don't think we were able to do that. But type into the chat if you filed at least one patent. And somebody raised a hand. Does somebody want to ask a question verbally? I saw somebody raise a hand. If you want to ask a question verbally, feel free to unmute yourself and ask the question. Okay, looks like 3 people in our group,
Okay.
28 filed for patents. That's interesting. Okay.
Okay, I'm just curious. This is just for us. What was the most interesting thing that you guys learned today? So we kind of use this feedback to gauge how to make this better for the future. So if there's something that you already know, maybe we can cut. It's good to be rejected initially. Yeah, it's very counterintuitive, but that's right.
Interesting. Okay.
Yeah. Okay.
Interesting. Yeah.
Yeah. So with the talk next month, when it comes to inventorship and co-ownership, we'll also discuss more about how claims work then. So if you're interested, we can go to that. Oh, how important is it to have claims in a provisional or to have provisional claims reviewed by a lawyer? Those are good questions. So when it comes to claims in the provisionals do not require any claims at all, right? Because you're not trying to get anything, you're not trying to get a patent issued. I would say it's important for 2 reasons why you might want to do that. One is that it helps you understand the scope of your invention, right? So it's more for yourself to understand that, especially if you want to conduct a prior art search, and then you want to tell a search firm or your patent agent or patent attorney to do that. Gives them some direction about how wide you want the scope of your claims to be. And then 2, and this is alluding to our talk in August, it helps determine inventorship. So one of the rules about who qualifies as a co-inventor of the patent application. You qualify if you contributed conceptually to at least one feature of one claim. So if the provisional patent application contains a bunch of stuff that one person had contributed to, but none of those make it into the claim, any claim, then they're not considered a co-inventor, right, for a non-provisional. So I would say it's not required to have claims in a provisional, but it is helpful for yourself. I guess another question I want to ask is, was there something you learned today that was different from your understanding of patents? So did I clear up any misunderstandings that anyone had? That'd be helpful to know as well. So it's a little bit different from what you thought was interesting or useful. But was there something that was counterintuitive or went against what you understood for? Okay, you mentioned that sending a notice of patent filings to competitors. Again, that's only when you're trying to enforce provisional patent rights, right? Not for fully fledged issued patents. Is this required to show evidence that they know what your company is doing, or to notify them that it is in contradiction of your patent filings? This is only to put them on notice if you're trying to enforce provisional patent rights. So that's after you have your patent application published, but before it issues as a patent. Once you get your patent issued, then there's no notice requirement at all to sue someone for infringement.
Somebody asked a question, would a provisional application with no claims be still used for negotiating a license deal or co-development with a large strategic partner? Legally, of course you can. Business-wise, it depends on a million factors. How strong is your technology? How valuable is your technology to the strategic partner? Certainly, if you have a very valuable technology that the strategic partner cannot do without, it's certainly feasible that they could license a provisional application. Although in my experience, generally companies will only license an issued patent, since that's only when they know what the scope of the claims are. And it sounds like we're running out of time for Venture Cafe. You guys should probably go to the next seminars. So I think we'll wrap it up here. Thank you very much for attending our seminar.
Yeah, and Matthew, you can please email us to answer that question. I have some thoughts on that. So yeah, email us if you have any final thoughts that we did not address. Okay, thank you everybody. And thanks Sean for hosting.
You guys know how to run a session. The fact that people stay late and ask questions is a good sign. So we're happy to be able to at least just play a part. So I want to thank you guys for volunteering your time to come on here and share the knowledge. It's really the best that we can, some of the best that we can hope for. So thank you. I know that you alluded to your next session coming up on August 13th. Be sure to come back for that, and we will see you out there later on. Have a great weekend, everybody.
Thank you very much. Have a
Great,
great
thank you.